Again, thank you for joining us today. My name is Josh Antis. I'm in the Community Relations Department at California Coast Credit Union, and we are excited to partner with Trust and Well today to talk about estate planning. Before we get started, just a few things I would like to mention. If you do have any questions, everyone is going to be placed on mute for today's presentation. However, if you do have questions, we will answer those for you. So please make sure to type in your questions in the question and answer box. We'll make sure to answer all those that we can. If there are questions that cannot be answered, any that might be legal in nature, then we will definitely follow up with you after today's presentation to get you the information you need. We also will be recording this session. So if you want to go back and review any of the information that we talk about today, we will have a recording of this session on the YouTube channel we have dedicated to you as City of San Diego employees. That will probably be up in the next day or two. You can go back and take a look at it at your leisure. And then also I want to mention that at the end of today's session, you will get a pop-up that says there's a survey that you can fill out. It's, I think, 7 questions. It's probably going to take you like 1 minute. But if you fill out the survey, we greatly appreciate it. And you will be entered into a drawing for a $25 Amazon gift card. And we'll be selecting 2 winners for 2 $25 gift cards. So please take the time to fill that out. If you can't do it at the end of the session, you will also receive an email in the next day or so that will have a link to fill out the survey as well. So no worries if you can't do it right away. Just keep an eye out for that email. Okay, so trusts and wills, a lot to talk about. I know we have a lot to cover, so let's get right to it. I want to introduce our presenter today. We have Molly Peters from Trust and Will, who is, Trust and Will is a partner of Cal Coast for, gosh, a couple, like 2 or 3 years now, I think, something like that. And they've done a lot of these presentations for us now. They're really great about answering all the questions that you have. And their products and services are amazing. Really, really are a really great partner of ours. So, and we're excited to have Molly with us. She's Senior Content Manager for Trust and Will. And again, she's got a lot to share. So we'll get right to it. Molly, go ahead and take it away.
Sweet. Thank you, Josh. Yeah, welcome City of San Diego employees to today's Estate Planning 101. I am your host today, Molly Peters. As mentioned, I am the Senior Content Marketing Manager at Trust and Well. So let's dive into today's agenda. We will be discussing the basics of estate planning. We'll start by defining what an estate plan is and what it does. Then we'll cover some of the key documents in an estate plan and how you can decide which documents are best for you. And finally, we'll conclude with who needs an estate plan, some of the most common reasons that it might be time to create or update your plan, and then how you can get started doing so. And as mentioned, if you have any questions along the way, we definitely encourage you to ask them using the chat function, the Q&A panel down at the bottom of your screen. We've got Jason here. He's one of our experts at Trust and Will, so he will be here to help you with whatever you need. So let's dive in. What is estate planning? That's why we're all here. Estate planning is planning today for what happens tomorrow. So at its most basic level, an estate plan lets you make decisions today about what should happen if you're unable to make decisions in the future, whether you're incapacitated or have died. It's really just a set of instructions where you can say what you want to happen to your assets, your belongings, and also your physical body. Okay, so why should someone care about estate planning? And what should really motivate someone to create their plan? This is one of my personal favorite questions to answer because there are so many reasons to care. So first and foremost is the peace of mind. The peace of mind that comes from completing your estate plan is priceless. You'll feel confident that you've taken the necessary steps to protect yourselves and your loved ones. And you can really rest easy at night knowing that you have a plan in place for what should happen if something ever goes wrong. Not something anybody loves to think about, but it's good to have that plan in place. And having that plan in place avoids leaving your loved ones with no guidance during what will, of course, be a very difficult time of grieving for them. Another major reason you should prioritize your estate planning is so that you can name legal guardians to care for your minor children and your pets. Knowing that your children and of course your pets too, will be safe and in the right hands should the worst happen to you, should also really bring you that peace of mind. The third reason estate planning is so important is that it can help you prepare for potential incapacity during your lifetime. So a lot of people assume that estate planning is only important after you pass away, but it can actually help you while you're still alive. In fact, a lot of studies show that a majority of Americans will be impacted by some kind of incapacity, either their own or a loved one during their lifetime. So having that plan in place can be critical in ensuring you get your desired outcome. And it also makes it a lot easier for your family to respect your wishes. A lot of people overlook that importance of the incapacity planning. Like I said, only thinking about estate planning as what happens after your death. But I've had a lot of experiences where the same people that go through this process wind up thinking that the incapacity planning is what mattered to them most. So as we can assume, all the decisions made in your estate plan are inherently personal decisions. So there's no way to have one default rule that matches your desires. And there's obviously no certainty that anyone else would make the same decisions as you would make for yourself. So when it comes to estate planning, there are several things to think about. Asset distribution and business succession planning, if that relates to you. So asset distribution is the big one. A primary motivation for many to create their estate plan is the ability to control where their assets will go after death. So perhaps you want to leave your belongings to your family. You can choose to have your assets benefit your family and loved ones. Or maybe it's a charity. Maybe you support a charity or an organization or any cause that was important to you during your lifetime. You can leave a portion of your estate, a specific dollar amount, to charity. And also, estate planning helps to minimize taxes to maximize the benefits to your beneficiaries. So many people equate estate planning with asset distributions. And while it certainly plays a large part, asset distribution is not the end all of estate planning. There's succession planning, there's end of life planning, there's that incapacity planning, which relates to your healthcare documents, which we'll talk about. And we'll get to all of that later on in this webinar. But the other thing I wanted to point out was business succession planning. So this is often overlooked by individuals who own their own business. But this business succession planning is critical to ensure that your business that you've obviously worked so hard on in your life doesn't just evaporate after your death. Because the absence of a plan can lead to a loss of valuation in your business, which can heavily impact and likely significantly decrease the inheritance that you leave behind to your beneficiaries. Okay, so now we've kind of got the why, but what really is an estate plan? An estate plan is just a set of documents containing instructions for what should happen if you cannot speak for yourself, whether that's due to incapacitation or death. An estate plan is typically multiple documents, not just one. And the documents in your plan will vary person to person, but should all be tailored to meet your needs, because each type of document is designed to do one thing. So your plan might focus on just one or two of these things, in which case you'd only have one or two documents, or your plan might be more comprehensive with a full suite of documents, again, depending on your needs. But the most typical, or the three most typical estate planning documents are wills, trusts, and your healthcare documents. So let's dive into each of those. A will. What is a will? Your last will and testament is a legal document that controls most of your assets when you die and only goes into effect after your death. So what is its purpose? A will handles fundamental needs for everyone. So if you're at least 18 years or older, which I'm sure we all are on today's call, an estate plan can benefit you. So there are three primary functions of a will. Firstly, to determine who will receive your assets after you die. Second, to nominate guardians for your children and pets. And then thirdly, to specify your final arrangement. So do you want a traditional funeral, or Perhaps you want a celebration of life memorial. Do you want to be buried? Do you want to be cremated? Decisions like that. So then what's the next logical question most people have? What happens if you die without a will? So this is called dying intestacy. That's hard to say, intestacy, or with no will. So as we've talked about, the functions of a will are essential. These matters like who will get your things, how will your assets be distributed, have to be addressed whether you have a will or not. So what happens if you don't is that state laws will fill in the gaps to make decisions for you. And this is one of the big common misunderstandings, is that a lot of people just assume that their state's laws, the default state laws, will give them the same result as what they would want, but that's not always the case. For example, let's say you are married with 2 kids. Your state's laws may provide that your assets are divided 1/3 in 1/3 to each of them. So 1/3 to your wife or husband, 1/3 to your kid 1, and 1/3 to kid 2. But maybe you don't want your kids to receive 1/3 of your assets when you pass away. Maybe your spouse is unable to maintain the household or their standard of living with only 1/3 of your assets. But depending on your state's laws, this is exactly what could happen if you die intestate. But with a legally binding will in place, the court is a lot more likely to honor those wishes after your death. So let's focus a little bit more about how wills work after death. So all wills go through probate, and probate is just a judicial process to determine the validity of your will. So was it signed? Was it notarized? Was it signed in front of witnesses? And also to appoint an executor. And if you don't have a will, the court will appoint an administrator, which will perform the same functions as an executor would. And usually that will be a relative or a loved one. But if you have no will, it may not be the relative or loved one of your choice. And to back up and clarify a little bit, the role of an executor is to manage the administration of your will. So they will collect your assets, they will pay off any debts or expenses or taxes associated with your estate, and then they will distribute your assets to your beneficiaries. So then back to probate. If you don't know, probate is often extremely undesirable. It's an incredibly slow process. It can take up to 12 to 18 months in California, and that was before COVID. So now it's expected to take up to 24 plus months as the courts begin to reopen. It's also a really difficult and stressful process. So it's a process that begins immediately after death, which is during a period of grieving and loss, which can often bring about resentments or lead to familial disputes, which obviously no one wants to deal with when they're grieving the loss of a loved one. And also probate's super expensive. So a $1 million estate can cost up to $50,000 or more in statutory fees for probate in California. And that $1 million includes the house and its gross value, not the equity that's been accumulated. So probate avoidance is a huge motivator for some, and one of the primary reasons that people often look to a trust. So what is a trust? A trust is a legal agreement between 3 parties. There's the settlor, also known as the trustor or the grantor, and that's who creates the trust and puts property into it. Then there's the trustee, and that's who owns and manages the assets in the trust. And then there's the beneficiary or beneficiaries who the trust is in favor of. So essentially the settlor, you, creates a trust, gives the assets in the trust to the trustee to hold and manage for the beneficiary or beneficiaries. In most cases, the settlor, trustee, and beneficiary are the same person initially, which sounds confusing, but think about it. That's because you're the settlor. In your lifetime, you're creating the trust, you're putting your assets into your trust, and while you're alive, you're managing those assets. So you're also the trustee. And during your life, because those are your assets, you're also benefiting from the assets in the trust. So you're also the beneficiary. So in lifetime, often those 3 roles are the same person, but those roles can split, obviously, after death. And then depending on the type of trust you have, those roles can shift during your lifetime. But We'll get to that later. So the purpose of a trust. There are 5 primary purposes. First of all is that probate avoidance. So this is key for many people because a trust is the easiest way to avoid all of those negative consequences I was just talking about in regards to probate. But a trust is not just about probate avoidance. So it can also manage and distribute your assets, which is also what a will does, but a trust gives you more control over when and how those assets are distributed. So you can put contingencies into your trust, like I don't want my assets going to my children until they've turned a certain age or, completed a certain life milestone, things like that. Another thing is that trusts apply during your lifetime and after death, which means a trust can be useful in planning for incapacity and can ensure that there's a seamless transition of control once you pass away. Also, trusts can provide for family. So this is a big motivator for people with younger children or blended families, because trusts give you more control over your assets that will eventually benefit your younger children. And trust gives you more control over providing for your spouse in his or her lifetime, but then ensuring that the assets pass to your children after your spouse's death. So it's all about that control. And then also trusts can help you minimize taxes. So back to the roles of a trust and choosing a trustee. So what really is a trustee? Best way to think of a trustee is like the CEO of your trust. Of course, that it's bound by law and the terms of your trust. But a trustee is still a critical role, which is why it's incredibly important to choose someone that you trust. Pun intended. But someone that you really are confident will have the ability to carry out the duties associated with administering your trust. And that can be, your spouse, children, relatives, close friends. People can also opt to work with what's called a professional trustee. So that's exactly what it sounds like. It's someone whose job is to be a trustee of people's trust. So that's also an option as well. So now let's talk about the types of trusts. There are several types of trust, more so than even what I'm going to talk about now, but these are some common ones that cover a wide variety of things. So there's firstly the revocable living trust, which is the most common type of trust. When people think about a trust, a revocable living trust is what they're thinking of. So a revocable living trust is created while you're living, and shocker, it can be changed or revoked during your lifetime, and also it avoids probate. Then there is a testamentary trust, which is less commonly used, but it's still an option, and it's created under a will, and it is only effective after death. And while it can be easier to create a testamentary trust, it often does still require probate. Then there are other types of trusts, and this really just depends on the complexity of your estate. So there's trusts that are used for tax planning. So credit shelter trust, what's called a Q-tip marital trust. And then there's also irrevocable life insurance trusts. And then there's trusts that are used for specific purposes. So special needs trusts are examples of that, asset protection trusts, Medicaid planning trusts. Again, these will all depend on your needs and what your ultimate goals are. So now you're probably wondering, what are the differences of a will and a trust? They kind of sound similar, and you're right, they have a lot of similarities, but they also have some big differences. So it's definitely important to note that a trust is not an alternative to a will and vice versa. Each document does something that the other does not. So they aren't alternatives. You can have both. The biggest similarity is that they both dispose of / distribute your assets. But the big differences are trusts avoid probate, wills go through probate. Trusts give you greater control over when and how your assets are distributed. Wills can be a little easier to set up. Trusts can be a little bit more work. Trusts apply during your lifetime and can help you plan for incapacity, while as wills only go into effect after death. And then wills are what nominate the guardians for your minor children and pets and can help you specify those final arrangements, whereas trusts do not. But trusts are often paired with a will as a set, and that's kind of that comprehensive suite of estate planning documents that I was referring to at the beginning. So when should people consider a trust? If you are a person with younger children, you may want to opt for a trust, because rather than having all of your assets go to your kids immediately when you die or right when they turn 18, a trust lets you set up triggers for asset distribution. So like I was talking about, if you want to give your kids their inheritance at a certain age, or perhaps they only get it if they've graduated college or, gone through another life milestone. So trusts can really help stretch out those distributions. Also, those with more complex family dynamics, like those in blended families or second marriages, trusts can let you benefit your spouse during their lifetime, but then ensure that your assets go to your children and not those from a different marriage or a stepchild. Obviously, if those are things you want, a trust can help you do that, but it's all about the control. So those with more complex family dynamics can really create specific provisions in their trusts. And then those who really value privacy, maybe another reason to consider a trust. All wills become public once a person passes away. So any of us can go down to our county recorder office and request to see somebody's wills, because that does become a public document, but trusts stay private during your lifetime and after death. Also, those with more assets often opt for a trust. So big reason for that is because of that probate avoidance. Also because trusts can help to minimize estate and income tax. So right now the federal estate tax is set at $11.58 million. So meaning anything over that amount is taxable. But that's today. That could easily reduce. It kind of just depends on the current administration. But with that, also people who want to have more advanced specific planning also may opt for a trust. And then also to stretch retirement distribution. So if you have retirement savings that you plan on leaving to your beneficiaries, a trust may provide a tax advantageous way to distribute those retirement savings over time. So now it's important to talk about healthcare documents. We covered wills, we covered trusts, but then the third most common of the estate planning documents are the healthcare documents. So that includes a power of attorney, a healthcare directive, also known as a living will, and then a HIPAA authorization. So your power of attorney. This is a person that you designate to make financial and non-medical decisions for you. So this is typically used in the event of incapacity, but can be set up in various ways. So for example, a non-incapacity example, let's say you are in the process of buying a home, and let's say you're out of the state or out of the country and you need to be there to sign some important paperwork. You can actually nominate your power of attorney to sign that on your behalf. Not because you're incapacitated, just because you're not physically there. Secondly is that living will or the healthcare directive. So this is where you specify your own medical preferences in advance and then designate someone to make other medical decisions for you, also known as your medical power of attorney. So this is where you decide if you want a DNR, if you want your organs donated, what level of effort do you want doctors to do if you are incapacitated? Are you wanting them to take extreme efforts, or do you want to opt if at a certain point you want to pull the plug, which is kind of a sad way to think about it. But the point is these are important decisions that you need to make in advance so that your loved ones aren't there having to make those decisions for you when they're already in a state of grief. And then lastly is your HIPAA authorization, which is actually frequently overlooked, but incredibly important because it ensures that your designated agents and representatives can speak with your medical providers on your behalf. and also make other decisions like consider cost of treatment, make important decisions if you are incapacitated. So you may have appointed that medical power of attorney in your living will or healthcare directive, but without the HIPAA authorization allowing them to speak with your medical providers, they will not be able to do so. So that's also an extremely important document. Okay. Lastly, let's cover who needs an estate plan. As I mentioned at the beginning, essentially all adults over the age of 18 can benefit from an estate plan. Oh, I am so sorry. That is my dogs, as you guys can tell, working from home life. Okay, so anyways, I apologize. Who needs an estate plan? So some of the top reasons people are triggered to create an estate plan, and these are all good reasons to create an estate plan. Firstly, getting married. So when you get married, you definitely want to set up an estate plan to ensure that your assets go to your spouse. If you have children, grandchildren, as you start accumulating more assets, you would want to start creating your estate plan. If you have any medical concerns, currently anything, genetic that you know that you have, you may want to create your estate plan sooner rather than later. Also, another big trigger that people often have to set up their own estate plan is when they deal with someone else's death. The loss of a loved one often triggers people to realize, hey, I should probably, set something up myself and for my family. And then lastly, for those approaching retirement. So when should you update your estate plan? The triggers that should warrant you updating your estate plan are definitely very similar to the triggers that should warrant you setting up your estate plan. So your plan should evolve as your life does. Estate planning is not a one and done transaction. Your life is constantly changing. And if your plan doesn't reflect those life changes, then the decisions you made 10 years ago may not be the ones that you still want in place today. So update your plan if you need to update beneficiaries. Let's say, you have grandchildren for the first time, you may want to include them in your estate plan. If you want to change the legal guardians of your minor children, so maybe your kids are getting older and you originally wanted their grandparents to be their guardian in the event something happened to you, but their grandparents may be aging, so you may want to opt for a different guardian. And then your preferences change. Your preferences can change over your life, and if they do, it's always important to update your plan so that it reflects those preferences. But again, those common triggers: births, any deaths in the family, a change in marital status, if you're nearing retirement, all of these triggers warrant just checking in on your estate plan. And then really just the passage of time. We recommend that every 3 to 5 years, you just look at your estate plan to make sure, A, that your preferences haven't changed, and B, if there's any, tax law changes that warrant needing a change of your estate plan. And then lastly, as your children become adults, they'll need their own plans themselves. So when they're under 18, you obviously have parental rights, but once your child turns 18, they should have legal documents to let you act on their behalf, especially in that incapacity planning. If something happens to them and they don't have a designated person to make those medical decisions, obviously, depending on state laws, as a parent, you will likely have that right. But let's say you want another person who's closer by to be able to be there and make those decisions. It's important that they have plans themselves. Okay, so now we have covered what an estate plan is, why it is so important to have a plan, but how can you go about putting a plan in place? So, of course, there's the old-fashioned route of finding your local estate planning attorney, or there's options like trust and will that provide you with the tools to create your own plan on your own time. So trust and will was really born from the recognition that the traditional way of creating an estate plan wasn't really working, just in the sense that the process was super expensive, it's confusing, it's intimidating. A lot of people don't want to, have to pay exorbitant lawyer fees or take the time out to meet with a lawyer. And then when their plans need updating, it's another call to a lawyer, another meeting you have to set up. So a lot of times people who went that route, either they didn't go that route and had no plan in place, or if they did go the traditional attorney route, plans are super outdated. Because like I said, it's harder to update. So we really tried to embrace technology and developed an easy, affordable way to create very high quality, fully customizable, legally valid documents that are on par with those traditionally created by attorneys. So we like to think of ourselves as the TurboTax of estate planning. We have 3 different products that are designed to handle everything from the most basic needs for new parents all the way up to complex trusts with sophisticated tax mechanisms for higher asset levels. So we've got our guardianship plan that's great for new parents who are looking to plan for their children. So this is typically an entry point for people to get started with their plans and just allows you to nominate legal guardians for your minor children. And then there's the will, which we've talked all about, and that covers a wide range of needs and also includes those important healthcare documents. So the power of attorney, the healthcare directive, and the HIPAA authorization form. And then the trust plan, which is most comprehensive. It is probate avoidance. It helps you get more specific and plan for, your younger children and spouse and to have more control over your assets, and then helps with tax planning. And that also includes a will and healthcare documents. So that's what we offer at Trust and Will. And even if you just want to learn more about estate planning to figure out what's best for you, maybe you're not quite ready to get started, you can go to trustandwill.com. We have a little learn link at the top of our page, which is really just a wealth of information about estate planning, what you need to know, how to decide what's best for you, common terms, anything you can think of. We've got information to help you choose a plan that's right for you. And then we also have representatives like Jason today, who you can chat with to learn more about the process and go over any questions that you may have at any time. And if your questions were not answered today, like I said, feel free to reach out and chat with our experts directly from our site. So with that, thank you all so much for being here today and giving me some time on your lunch break to learn about the importance of estate planning. If you are ready to get started, you can visit calcoastcu.org/estate-planning, and you will receive 15% off your estate plan through Trust and Will. And with that, thank you so much.
All right, thank you so much, Molly. A lot of great info. There was a couple of questions that came through. I don't know if Jason might be in the process of answering these, but outside of real estate, pensions, 401k, stocks, bank accounts, etc., where do autos fit into an estate plan?
Let me pull that up. Is that directed towards Jason?
Either one of you. Oh, Jason answered in the chat. I'm sorry, he just answered it. Yeah, like I said, he's probably answering it now. And then there was a question about the costs to the different plans that you have.
Yes. So our guardianship-based estate plan, so that's the one that just allows you to nominate guardians for your children and your pets. That starts at $39 for a single. Then we have our will-based estate plan that I mentioned, which starts at $159. And then our trust-based estate plan starts at $599.
Great. I think we'll give everyone another minute or two to see if there's any other questions. In the meantime, I just want to mention that we will be continuing our webinar series into April. Let's see, it looks like, let's see. So on April 20th, we're going to have our Calco's financial team with us to talk about investing. So be on the lookout for that email to register for the next month's session. Otherwise, Molly, we're getting a lot of great jobs and thank yous in the chat. We really appreciate you joining us today and sharing all the great information. If you do have any other questions, we're always available. When it comes to CalCoast, there's a million ways to contact us. Well, not a million. There's many ways to contact us. Branch, you can go to a branch, call us, go on our website. You can even message us on social media. We're very, we'll answer on social media as well. Very active there. So don't hesitate if you have any questions at all. And of course, please visit calcocu.org/estate-planning to get started with your estate planning needs. All right, I'm not seeing any other questions, so I think we'll go ahead and wrap it up. Again, thank you everyone for joining us today. Thank you, Molly and team.
Thank you.
Enjoy the rest of your day.
Bye, everyone.